My dad can't afford a lawyer, so I'm going in there myself." Nadia Ferreira was 26 years old when she said those words to the duty clerk at the Ontario Superior Court of Justice in Hamilton. She was wearing a pressed white blouse, hair pulled back, and she was carrying a manila folder stuffed with documents held together by a binder clip she'd borrowed from a FedEx office on King Street. The clerk looked at her, the way people look at someone who's just announced they're going to swim the Great Lakes. Behind the clerk, a man in a charcoal suit leaned against the counter. Rowan Pallister, senior counsel for Breckfield Property Holdings. He'd been practicing law for 31 years. He looked at Nadia the way a hawk looks at something small moving through tall grass. "You're representing yourself?" he said. Not a question, a verdict. Nadia didn't look at him. She handed her documents to the clerk, filing on behalf of the respondent, Elias Ferreira. Pallister's associate, a young woman with a leather portfolio, leaned in and whispered something. They both looked at Nadia, then they turned back to each other and smiled. Nobody stopped smiling, nobody said anything, and that was its own kind of answer about what kind of room this was going to be. I'm Blake Uncovers. I find the stories that get buried under paperwork and power, and the quiet agreement of people who benefit from the silence. This one was buried in Hamilton, Ontario, under 17 months of legal filings, a property dispute most people would have settled for pennies, and a corporation that had learned a long time ago that exhaustion is the best weapon money can buy. Hamilton sits at the western end of Lake Ontario, at the foot of the Niagara Escarpment. There's a part of the lower city, not the gentrified part with the coffee shops, not the mountain with the big houses. There's a stretch of the north end where the steel industry used to be the whole world. When the mills scaled back, the world got smaller. The houses stayed, the people stayed, and so did the memory of what it felt like to own something with your hands. Elias Ferreira had owned his property on Ferry Street East for 41 years. He'd bought it in 1983, a narrow lot with a 2-story house and a detached garage he'd converted into a small engine repair shop. He'd come from the Azores when he was 22 with a technical diploma, $200 Canadian, and the kind of stubbornness that specific ocean winds produce in people. He'd fixed engines for 40 years, lawnmowers, outboards, generators, the occasional motorcycle. Nothing glamorous, consistent, honest. His wife, Celia, had died in 2018 of a pulmonary embolism that nobody caught in time. After that, the shop got quieter. Elias got quieter. His granddaughter, Nadia, who had been living in Ottawa working a government contract, came home to Hamilton 6 months after the funeral and didn't leave. She told herself it was temporary. By the time Breckfield Property Holdings served the notice of claim in the spring of 2023, she'd been there long enough to know every crack in the kitchen ceiling and every name of every customer her grandfather had kept for 20 years. The claim was 43 pages long. Nadia read it the night it arrived, sitting at the kitchen table under the single overhead light while her grandfather slept. The language was dense and deliberate, the kind of legal writing designed not to inform but to obscure. What it said, stripped of its Latin and its subclauses, was this. Breckfield contended that a strip of land along the eastern edge of Elias's property, 6 feet wide, running the full depth of the lot, legally belonged to them. That 6 feet included the eastern foundation wall of the garage. Without it, the garage couldn't stand. Without the garage, there was no shop. Without the shop, there was nothing left of what Elias had spent 4 decades building. They were offering to purchase the disputed strip for $11,000. They were giving him 60 days to respond. Nadia set the papers down and looked at the photo on the refrigerator. Her grandmother, laughing at something off camera, the kind of laugh that takes over your whole face. She picked the papers back up. Over the next 3 weeks, Elias called every lawyer he could find with a reasonable distance of Hamilton. The first one told him the claim looked legally sound and suggested he take the offer before it got worse. The second quoted a retainer of $9,000 just to review the file, and said, with no apparent irony, that he'd need to know whether Elias could sustain a prolonged litigation before he could advise him on whether to litigate. The third was a legal aid clinic in the East End. The intake worker was kind, genuinely kind, and told Elias the wait list for property disputes was 8 months. The hearing was in 11 weeks. Nadia sat in the back seat for every single one of those appointments. She didn't say much. She wrote everything down. She'd spent 4 years in the Canadian Armed Forces before her government contract. 2 years of that in an intelligence support role that she doesn't talk about, and that explains, if you know what to look for, why she sits with her back to the wall in restaurants, and why her handwriting is so precise it looks almost mechanical. She was trained to read situations, to find the load-bearing piece, to understand that most problems, when you strip away everything theatrical, are actually much simpler than they've been made to look. She was reading this one. The night after the third lawyer visit, she sat with her grandfather at the kitchen table. He'd made tea. He always made tea when things were bad. It was something to do with your hands. "Tell me again," she said, "about the fence." Her grandfather wrapped his hands around his mug. "I put the fence up in 1991, same year as the city redid the sidewalk. I remember because the inspector came out, same week. He walked the property line himself, said the fence was fine. Nadia wrote it down. And the Hendersons, she caught herself, wrong story, wrong city. And the Vance property next door, when did Breckfield buy that? Last October." He paused. "They tore down the house in December, before they filed on you. 3 months before." Nadia looked at him. "And the survey they submitted with the claim, did you look at who conducted it?" "Man named Harlow, R. Harlow, registered land surveyor, license in Ontario, has a stamp. I'm going to need to find his other work." Elias looked at his granddaughter for a long time. She had her grandmother's eyes. That same quality of attention, like the room got a little steadier when she turned it towards something. "Nadia," he said, "you're not a lawyer." "No," she said, but neither was the person who filed this claim thinking clearly, because if they had been, they would have filed it somewhere the public records aren't so easy to pull. She didn't sleep that night, or the next. The Ontario government maintains a public land registry system. It's not easy to navigate. It wasn't designed for people without real estate law training, but it's there. Every parcel, every deed, every registered survey, every encumbrance, every historical boundary adjustment, all of it, accessible, public. Most people don't know it exists. Most people who do know it exists pay a lawyer to look at it for them. Nadia taught herself to use it in 5 days. She pulled the original survey plan for her grandfather's property, registered in 1983 when he bought the lot. She pulled the survey Breckfield had submitted with the claim. She pulled the survey used in Breckfield's acquisition of the Vance property next door the previous October. She laid them side by side on the kitchen table and took photographs. Then she opened them on her laptop, scaling them to the same dimensions. They didn't match, not in the obvious way of 2 drawings with different lines. They matched everywhere except one place. The eastern boundary of the Ferreira lot. In the original 1983 survey, the eastern boundary was measured from a concrete monument at the northeast corner of the block, a standard reference point registered with the city of Hamilton. In Breckfield's survey, conducted by R. Harlow, the starting point was shifted. Not dramatically, just enough. The measurement began from a secondary reference point 1.8 meters east of the primary monument, 1.8 meters, just under 6 feet, the exact width of the disputed strip. Nadia sat with that for a moment. Then she went back to the registry and pulled every survey filed by R. Harlow in the past 3 years. There were 9. 4 of them were for properties acquired by Breckfield Property Holdings, or its numbered subsidiaries. Every one of them used the same secondary reference point. Every one of them resulted in a boundary that favored Breckfield. Same surveyor, same shift, same client, same outcome. She wrote in the margin of her notepad, "Harlow moved the line. He moved it for Vance. He's moving it for us." She stared at that for a long time. Then she turned the page and started looking at something else. Ontario's Municipal Conflict of Interest Act requires municipal officials to disclose financial interests in matters that come before them. The Ontario courts have their own judicial conduct guidelines and provincially appointed adjudicators, including certain tribunal members involved in property matters, are required to file annual disclosure statements. She hadn't known this before she started reading. Now she did. The Breckfield claim had been routed through a specific regional property tribunal before escalating to Superior Court. One name kept appearing in the procedural history. Adjudicator V. Crowell, full name Vincent Crowell, had issued 2 preliminary procedural rulings favoring Breckfield in the early stages, both of which had made it harder for Elias to access documents and easier for Breckfield to set the timeline. It took her 2 hours to find Crowell's disclosure filing. It was publicly available on the tribunal's website, buried under an administrative archive link that hadn't been updated since 2021. Page 4. Line 11. Directorship interest. Pemberton Realty Trust, a subsidiary of Breckfield Capital Group. She read it 3 times. Vincent Crowell had a seat on the board of a subsidiary of the parent company that owned Breckfield Property Holdings. He had a directorship interest, which, in plain language, meant he was paid to sit on that board. In a company that shared a corporate parent with the entity currently suing her grandfather. He had never disclosed this in the proceeding. He had never recused himself. He had issued rulings that disadvantaged her grandfather and called it neutral procedure. Nadia's hands were shaking. Not from fear. She'd been in situations that produced genuine fear, the kind that comes with physical risk, and she knew the difference. This was something else. This was the specific feeling of understanding a system completely for the first time. Not abstractly, the way you understand that corruption exists in the world. Specifically, the names, the numbers, the filing dates, the money. She picked up a pen. On a single index card in her precise mechanical handwriting, she wrote 2 sentences. She underlined them both. She placed the card in the front pocket of her grandfather's old leather briefcase, the one he'd brought from the Azores in 1981, and used until it cracked along the top seam and he retired it to the closet shelf. She asked him for it the next morning. He handed it to her without asking why. He'd seen her face at breakfast. He knew. I need to stop here for a second. Because before I tell you what happened in that courtroom, I want you to understand something about who Nadia Ferreira was when she walked through those doors. She wasn't a lawyer. She had a college diploma, a government clearance she couldn't talk about, and a grandfather who made good tea and fixed engines and had never asked anyone for anything in his life. She'd spent 4 years learning how to stay calm in rooms where the situation was designed to make you panic. She'd spent 4 years learning that preparation is the only thing that actually works, that you can't outmuscle a system. But sometimes, if you're patient and methodical, and you read every document twice, you can find the one thread. She'd found the thread, and she was about to pull it in a courtroom where nobody expected her to have one. Here's what she walked into. The courtroom was bright in the institutional way, fluorescent and still. Justice Madeline Corbett presided, a different adjudicator, now that the case had escalated to Superior Court, which meant Crowell was no longer in the chair. But the record of his rulings still existed. Everything he'd decided was still on file, which meant it was still evidence. Rowan Pallister delivered his opening like a man who'd given it 100 times, because he had. Smooth, unhurried, he presented Breckfield as a responsible developer, contributing to Hamilton's revitalization, creating housing in a city that needed it. The survey was conducted by a licensed professional. The boundary discrepancy was a matter of historical record-keeping, not misconduct. The law was clear. The mathematics were clear. His client had been more than fair in its offer. He didn't once look at Nadia during the opening. Nadia stood. She was not polished. She knew it and didn't try to hide it. Her opening was shorter, quieter, and much more specific. My grandfather has owned this property since 1983. He has paid his taxes every year. He has maintained the eastern fence line in the same position since 1991, a position confirmed by a City of Hamilton property inspector the year it was erected. No one questioned that boundary for 40 years. Not until Breckfield Property Holdings purchased the lot next door and commissioned a survey from their preferred contractor. She paused. Mr. Pallister says this case is about mathematics. He's right. The question isn't what the numbers say. The question is which numbers and who chose the starting point. She sat down. Pallister looked at her for the first time that morning. Something in his expression shifted, just slightly. Not respect. Something more unsettled than that. The morning session went the way it was built to go. Pallister examined the survey. He walked Justice Corbett through the boundary measurements with the confidence of a man who had done this so many times the words came out of him automatically. He had an expert witness, a second surveyor, who confirmed that Harlow's methodology was within accepted professional practice. He had photographs of the lot taken by a Breckfield contractor that showed the garage's eastern wall sitting on what was now designated Breckfield land. When he finished, he sat down with the satisfaction of a man who'd already written the invoice. Nadia cross-examined the expert witness. She started slowly, the way she'd planned it, established the baseline, let the witness feel comfortable. You've reviewed Mr. Harlow's survey methodology? I have. And you confirmed the survey used GPS coordinates for its primary reference point? Correct. Specifically, coordinates from what Harlow identified as the municipal boundary marker at the northeast corner of the block. DOP. Yes. I'd like to show you the original 1983 survey plan for this property. She held up the document. In this plan, the primary reference monument is listed as a concrete post at the northeast corner. Can you see the coordinates recorded here? I can. Can you compare those to the coordinates Harlow used as his starting point? A pause. They're not identical. They're 1.8 meters apart. There may have been an updated GPS calibration. I requested confirmation from the City of Hamilton's survey office of any updates to that reference monument in the past 20 years. She produced a letter, stamped, dated, official letterhead. There have been none. The monument coordinates on file with the city are identical to the 1983 survey. The discrepancy is in Mr. Harlow's starting point, not in the monument. The witness looked at the letter. He looked at Pallister. Pallister's pen had stopped moving. I'd need to review. I've also pulled 3 other surveys conducted by Mr. Harlow for properties acquired by Breckfield or its related companies in this region over the past 3 years. She laid them on the table. Each one uses a starting point that is not the primary municipal monument. Each one results in a boundary line that advantages Breckfield. Same surveyor, same client, same directional shift, same outcome. The room changed, not loudly, quietly, the way a room changes when something that was invisible becomes visible. Justice Corbett leaned forward. Pallister stood. Objection. The respondent is presenting documents not in evidence. They're in the public land registry, Nadia said. Every one of them. I can provide the access confirmation numbers. Justice Corbett looked at her steadily. You pulled these yourself from the provincial registry? Yes, Your Honor. A moment. I'll allow them, Mr. Pallister. You'll have the opportunity to respond. Pallister sat down. His associate was typing something frantically on a laptop. Lunch recess. In the hallway, her grandfather sat on a bench and pressed his hands together between his knees. He was 76 years old, and he looked every year of it today, the overhead lights picking out every line in his face. He didn't speak for a while. Nadia stood at the window. Her reflection looked back at her, faint against the gray Hamilton sky. She opened the briefcase, She pulled out the index card. She read the 2 sentences again. She put it back. Her grandfather spoke without looking up. Your grandmother used to say that a document never lies. People lie. Documents just sit there telling the truth until someone looks. Nadia looked at him. She was talking about grocery lists, he said, but I think it applies. Nadia almost smiled. For the first time in 11 weeks, she almost smiled. Pallister found her in the hallway before the afternoon session. He didn't crouch down to her level, the way a man certain of his power might. He stood at a measured professional distance, which told her he'd adjusted his read of the situation. Ms. Ferreira, he said, what you've done this morning is genuinely impressive for a layperson. He said, layperson the way you'd say child, but you've shown a pattern you can't prove was intentional. A coincidence in methodology isn't evidence of fraud. I know, she said. He waited. That's why I have something else. She walked back into the courtroom. The afternoon session opened with Nadia calling Harlow to the stand. Pallister objected. Justice Corbett overruled. Raymond Harlow was a compact man in his 60s with a surveyor's tan, and the careful stillness of someone who knew he was about to be asked questions he didn't want to answer. He'd been in the field for 28 years. He answered the first several questions with the ease of a professional in his territory. Then Nadia placed both survey overlays on the table, side by side, the 1983 plan, his plan. She walked him through the reference point discrepancy with the patience of someone who had spent 3 weeks learning exactly how to do this. Mr. Harlow, can you explain why your starting GPS coordinate differs from the registered municipal monument? I used updated field data. Updated by whom? From my field equipment. Your field equipment produced coordinates that are 1.8 meters off from the registered monument in the same direction. For every Breckfield survey you've conducted, field variance is normal, not in the same direction every time for the same client. She placed the 4 surveys in a row. Can you show me one Harlow survey for a non-Breckfield client where your reference point is similarly offset? Silence. Mr. Harlow, did Breckfield or anyone representing them provide you with specific coordinates to use as your reference point? He looked at Pallister. A reflex, not a decision. I received a site data package from the client's project office containing the starting coordinates, among other things. The room went very quiet. Nadia waited. 3 seconds. 4. She'd learned this from her military training. Silence is pressure. Let it build. Don't release it early. Then she reached into the front pocket of the briefcase. She took out the index card. Mr. Harlow, I have no further questions for you. She turned to face Justice Corbett. Your Honor, I'd like to place one final item into the record, not for the witness, for the court. Pallister was on his feet. Objection. The respondent has the right to address the court, Justice Corbett said. Her voice was even and gave nothing away. Continue. Nadia held up a printed page. It had a yellow highlight on line 11 of page 4. This is the annual disclosure filing of Vincent Crowell, the adjudicator who issued 2 preliminary procedural rulings in this matter before it came to Superior Court. This document is publicly available on the Tribunal's administrative archive. It shows that Mr. Crowell holds a directorship interest in Pemberton Realty Trust, a subsidiary of Breckfield Capital Group, the parent company of the respondent. Mr. Crowell never disclosed this interest during the proceedings in which he ruled. He never recused himself. She set the page on the table. Every ruling he made that disadvantaged my grandfather, limiting document access, restricting our response timeline, those rulings are now on this court's record. And the person who made them had a financial interest in the outcome. She looked up at Justice Corbett. My question for this court is not about survey coordinates. It's about this. If the preliminary process that shaped this litigation was presided over by someone who financially benefits from the result, what is the integrity of the proceeding that followed? Pallister was speaking. Justice Corbett's gavel came down. The courtroom had stopped being quiet in the polite way. It had started being quiet in the other way, the way that happens when something fundamental shifts. Pallister's associate had her phone out. Pallister himself was very still, in the specific stillness of a man doing rapid calculations. Justice Corbett looked at the disclosure document. She looked at Nadia. She looked at Pallister. "Mr. Pallister, were you aware of Mr. Cruel's directorship interest?" A very long pause. "I was not, Your Honor." Whether that was true, Nadia never found out. It almost didn't matter anymore. Justice Corbett set down her pen. "This court is adjourned. I'm issuing a formal referral of these proceedings to the Ontario Judicial Council and the Ministry of the Attorney General for review of the Crowell matter. This case will not proceed to a ruling until that review is complete." She looked at Nadia. "Miss Ferreira, I want to note for the record that the level of preparation and the quality of the documentary evidence you have presented today is," she paused, as if choosing the word carefully, "remarkable. This court will ensure that the record reflects the procedural concerns you've raised." Nadia nodded. "Thank you, Your Honor." Justice Corbett stood, and the courtroom stood with her, and when she walked through the side door, the room exhaled all at once. What happened next took months, the way real things usually do. The Ontario Judicial Council launched a formal review of Vincent Crowell's conduct. The review found that Crowell had failed to disclose a material financial interest in contravention of the Adjudicative Tribunal's Accountability, Governance, and Appointments Act. His appointment to the tribunal was terminated. Both procedural rulings he had issued in the Ferreira matter were voided. The case was reheard before a new adjudicator. Raymond Harlow's surveying license was referred to the Association of Ontario Land Surveyors for a professional conduct review. He surrendered it before the hearing concluded. The boundary claim against the Ferreira property was dismissed. Breckfield Property Holdings withdrew its offer of $11,000. It withdrew the claim entirely. 3 weeks later, it withdrew its development application for the North Hamilton site entirely, citing project restructuring. 2 local journalists picked up the story. A third one, from the Hamilton Spectator, wrote a longer piece about the Crowell connection and the pattern of Breckfield acquisitions in the lower city going back 5 years. 4 other property owners who had sold under pressure from Breckfield in the same period filed requests for review with the province. The garage on Ferry Street East is still standing. Elias Ferreira repainted the sign that spring, not because he had to, but because he wanted to. Nadia held the ladder. He made tea after, the way he always did, and they sat in the garage in the 2 old chairs he kept by the workbench, and the afternoon light came in through the bay door in long gold lines the way it always did at that hour, and he didn't say much, and she didn't either, because some things sit better in silence. The cracked leather briefcase is on the shelf again, but Nadia knows where it is. "There's something I want to say before we're done here. I know Hamilton. I know what the lower city looks like when development money starts moving through it. What gets torn down, what gets built, who gets called back to negotiate, and who gets served a notice. I know what it looks like when a system is designed so that the cost of fighting it is higher than most people can pay. Legal fees are expensive, exhaustion is free. And people who have power understand that if they can just make the process complicated enough, long enough, expensive enough, most people will eventually take the $11,000 and walk away. Nadia Ferreira didn't walk away. She didn't have a law degree. She didn't have connections. She had a laptop, access to public records that nobody told her she could use, and 4 years of training that taught her to stay methodical when everything is designed to make you panic. She found the thread because she looked, because she didn't accept that the system was simply the way it was, because she asked the question everyone else had decided not to ask. If this story meant something to you, share it. Send it to someone who's been told that the process is too complicated, that the cost is too high, that the best option is to take what's offered and be grateful. Tell them about a woman who read every document twice and found on page 4, line 11, the thing that brought it all down. Drop a comment. I read everyone, because the records are public. The information is there. It's always been there.